All right, welcome everybody to yet another risk reduction class. This class, we are going to discuss the forms that are associated with the new BRBC. We covered the BRBC a couple of weeks ago and the new BRBC, and some of the associated forms were also recently modified for the July 24th release. So these new associated BRBC forms are now in your library. And I just want to review with you quite a few forms. I'll go through them briefly on some of the important points in those forms. So let me share my screen and get the presentation underway. All right, everybody can see my screen, hopefully. And again, we've all been through this drill, how to reach me. I'm happy to help you. Of course, during business hours, it's best to call my direct line. But if you call my cell, I'll catch it. But it may take me an extra hour or two. Sometimes Mike calls my cell, and it takes me an hour to notice that I'm watching it pretty closely, try to catch it. But call either number. But the direct line's the best line if you've got a problem, because it lights up my phone, and on my phone quite a bit, obviously. Email me, of course. And then after hours, weekends, text my cell. It's best if you text me. You're welcome to call and leave me a message. If you text me, I'll call you back. I don't keep the ringer on the weekend. Uh, my wife, I don't want to disturb her. So, okay. Some of you are familiar with this. This is a Reinhardt. I think it's Niebuhr. I think that's the way you pronounce him. He's a Presbyterian minister. This quote was became popular in the 30s and has often been quoted since then. And I want to remind you, some of you who are familiar with it, about it, and maybe introduce it to some that you don't, that aren't familiar with it. Grant me the serenity to accept the things I cannot change, the courage to change the things I can, and the wisdom to know the difference. Let me give you a little wisdom. You are not going to change the NAR settlement, So the NAR settlement is something you cannot change. So lean into it, accept it, abandon an effort to persist in broker-to-broker compensations. Although it's not yet illegal, clearly the handwriting's on the wall. It's coming out of the MLS as a part of the court settlement and the following settlement agreement, the court decision rather, and the settlement agreement. The DOJ is leaning heavily on the real estate industry to get rid of broker-to-broker compensation. The problem from the DOJ's perspective is when broker-to-broker compensation occurs, when it's first created, they believe it's fixing the commission to the buyer's agent. So you're fixing the commission you'll pay the buyer's agent to represent the buyer. And guess who's not there? The buyer. And the buyer wants, obviously wants a say in how much their agent is paid, because how much their agent is paid truly, I think all of you would agree, affects the purchase price. So as much as the old system had a lot of merit and worked real well, the argument against it is not invalid. And that is the crux of all of these lawsuits. So although it is not illegal to do, as I said, CAR is not supporting it in any way, in any form. When CARs first revised these forms, they included broker-to-broker compensation, and they got savaged by the consumer organizations for that. And so that's why CAR delayed the release of some of those forms. They gave it a second look, and they've come to the same thing I'm suggesting to you, and that is, let's lean into what is probably the inevitable result that will come from all these lawsuits, and that broker-to-broker compensation will in fact completely go away. Again, it's not illegal. If your seller absolutely insists on doing it, call me. I'll talk with you how to do it. But as you've already learned, these things are not available. This is not available in car forms. Now, before we get into the BRBC, I want to take a real quick moment because this has come up multiple times, and that is the SELM, the seller's instruction to exclude a listing from the multiple listing service, and the MLSA, the new addendum, which discusses the MLS and excluding it. It has options in the MLSA to exclude your listing from the MLS in various manners. So I've been called repeatedly on why do I have to do an SELM when it's redundant to the MLSA? And in fact, you're right. But the reason you have to do it is because the MLSs require it. So let me walk you through it real quickly. The SELM, if you're real familiar with it, or even at all familiar with it, it's pretty straightforward. Talks about the multi-listing service, talks about the benefits of the multi-listing service, talks about mandatory submission of all listings to the MLS. Now, the MLS requires or does not require brokers who participate in the service to submit their listings. Our MLSs, both the San Diego MLS and CRMLS, do require. So when you use the SELM, the one thing I want to tell you is on 3A, it do not check this box because there are a couple of MLSs in Northern California that do not require submission of listings to that mentioned MLS. Our MLSs do. So in 3A, it's not an option. You are required, at the very least, to notify the MLS that you have a listing. And talks about public marketing. And then there's another box there that the MLS has not adopted the clear cooperation policy. That is not an optional box for us. Why? Because our two MLSs I've mentioned have adopted the clear cooperation policy. So don't check 3D either. That is not a paragraph that applies to any property you're going to put in any Southern California MLS. I don't think there's a single one in Southern California. There are several a little north of us. They also have clear cooperation as a mandatory policy. Okay. So now the seller instruction, that's the whole purpose of the form, right? Either do not market the property in MLS until, or do not market the property in the MLS at all. And so those are the two options, and that's how you fill out an SELM, and you will be required to do it, even though you're going to use the MLSA as a part of your listing contract. We require it. It's on the checklist, the broker file checklist. We require the MLSA as part of your listing paperwork. And the good news for you is it does print with the RLA, the new RLA. And so real quickly, paragraph 1 of the MLSA talks about listing service. It's very similar to the SELM, paragraph 1. Broker is a participant of the multiple listing service specified in 2E of the listing agreement. The SELM has a place where you put the MLS you're a participant of. When you look at the MSLA, there's no place to list the MLS you're a participant of, but it's part of the new listing contract, paragraph 2E. So benefits of using the MLS, of course, I don't need to review all that with you. You all know that. Similar to SELM paragraph 2. So you can see the redundancy. I'm with you completely. Very redundant. Public marketing of property. SELM paragraph 3. What do you know? It's there. So again, and seller instruction. Now the MLSA is where you would instruct the seller would instruct you not to market the property in the MLS either. And that's similar to paragraph 4 of the SELM. And either the seller instructs the marketing to begin on a specific date, or which is SELM paragraph 4, or seller instruction not to market the MLS at all. And again, that's part of paragraph 4. It's redundant. I understand. Clear cooperation, do not check this box on the MLSA. because this does not apply to San Diego or MLS or CRMLS. Okay. So both the San Diego MLS and CRMLS require that MLS participants submit a listing or an authorization to exclude a listing within 48 hours of taking a listing. So if you take a listing and put it in the MLS, you've notified them because it's in the MLS. By the way, if you're going to put it in the MLS and it's coming soon, you're not excluding it from the MLS. It's in the MLS. It's coming soon. As most of you know, coming soon caps at 21 days. And this question's come up multiple times. You cannot exclude a listing, and then when you put it in it's coming soon. You could only put it in it's coming soon as a new listing. So keep that in mind. So either way, you put it in as a listing, you put it in it's coming soon, you've notified the MLS. If you're not putting it in the MLS, then you need to send an authorization to exclude the listing. And we've checked. Lindsay checked. I say we. I couldn't do my job without Lindsay and Emily. Lindsay checked with both the San Diego MLS and the CRMLS, and they do not accept the MLSA as a document to document excluding the listing from the MLS, although it does that, as I just showed you. I understand that, but they require an SELM. So you're going to have an SELM with you if you're going to discuss with the seller. They don't want to put it in the MLS right away. And then again, you want to send that SELM into the appropriate MLS within 48 hours. Okay, hope that helps. Hope that clarifies some questions. If you still have a question, put something in the chat. Lindsay will call on you or tell me the question at the end here. Let's jump into the buyer representation and compensation agreement related forms. Let's take a look at those real briefly. So the first form I want to talk about is the BIPP, the Buyer Identification of Preferences and Priorities. This is an optional form, but it's contained in the BRBC. It's mentioned in paragraph 2C of the BRBC. And it's a nice little form. It gives you a lot more information about the kind of property the buyer is looking for. It is not required for you to earn compensation. What the properties that you are entitled to compensation on, if it's a non-exclusive, are properties that you have broker involvement in, or if it's an exclusive, the properties described in the BRBC. What's described in the BIPP, the Buyer Identification of Preferences and Priorities, you don't have to match that. So hope that's clear. Because it's a evolving situation with buyers, they think they want a property in one area or a 3-bedroom, and now maybe they've decided they want a larger house, so when you do one of these, number it. Be sure to fill in a number. And then also this, you can supersede an earlier number. So if you're doing number 2 or number 3, they just check this box, and the number 3 is what you put there. If this is the third one you're doing, 3 would go up here and 3 would go here. It's the third one you're doing, and it's replacing an earlier one. All right. Identifies the parties. You haven't identified a property yet, but it does identify the representation period. And it talks about how beneficial it is to both parties, both the buyer and the broker, because remember, this is an attachment to a contract between you and the buyer. And so both parties benefit from the buyer identifying what their preferences are. So nice form. And then you can see in detail all the different things that you can check. That doesn't mean they can't buy a house that's not one of these. You can show them houses that are not one of these checked things. But it's a really nice form to kind of guide you and guide the buyer as to what kinds of property are we looking at here. And then anything they put on this form is confidential between you and the buyer. And the buyer will, they're not aware of any other significant preferences or priorities that would affect the buyer's effort or decision. to buy the property, and they've not made any verbal representations. This is a very nice paragraph. It's sort of a lead in to the BMISP, which I'll cover in a minute. But this is helpful. And of course, the buyer signs it, and then you acknowledge a copy of it. All right, I do want to talk about the BMI SP, which is the new BMI. And some of you have heard about it many times. Some of you are sick of hearing about it. Some of you, as I always say, love the form because why? Because you've successfully, the form has successfully prevented a claim, an incorrect claim, an unfair claim, if I can say that, against you. The buyer makes a representation after close of escrow. They got a property. Now they're stuck with it, they say, and they never wanted a property like this. And they told their agent they didn't want this, and their agent didn't protect them to avoid them from getting all of those kinds of issues. They can be very serious, by the way. Absent anything in writing, it's a he said, she said. And as I said in a recent call, everybody knows the adage, innocent until proven guilty, but the corollary for real estate is it's the reverse of that for real estate agents. Courts tend to give buyers and sellers a lot of credit to their arguments that they told the buyer, because the reason the courts do that, I'll tell you outright, because the courts believe you're a professional. And if they told you something, or they're saying something that's not so, you would have something in writing to document it's not so. And the fact that you don't have something in writing, that works against you. The fact that you don't have a BMI that says that they weren't worried about whatever it is they bought works against you. So that's why you want this form, because this works heavily in your favor. So real quickly, take a look at it. You identify the buyer, the broker, and the property. And then the buyer's obligation to disclose any material issues, anything that would cause them not to want this property. And they list those things here. And if they have nothing to say, you create a text field. As the buyer's agent, when you hand them a BMI, by the way, a BMI is only required when you represent a buyer. Listing agents don't need them. And when you have a listing and you sell the listing, you don't need to ask the other side, the buyer's agent, hey, where's your BMI? You don't need it. It's a buyer to buyer broker form. All right. So the buyer broker, when they give the buyer the BMI, create a text field here. You want the buyer to fill this part of the form out. You do not want to do that. Why? Because courts have looked at who put stuff on the blanks. If you put stuff on the blanks, it diminishes the value of this form. When I can say, and I have in court, I have said, no, Your Honor, the agent did not fill this out. That's not how it's done. Take a look at the text field. It's created for the buyer to type in what they typed. And the courts recognize that. So if the buyer says, well, gee, I don't know nothing really, I want to just check out the house. Okay, well, we'll do that. Anything you special? No. Okay, well, then just put none. They might say, well, gee, I don't know. I haven't done an inspection yet. Well, clearly the physical inspection is important to you. So maybe write down physical inspection. Assist the buyer in advising you what they don't want, because you want to know what they don't want, what they're concerned about. We had a buyer tell us they're very concerned about asbestos. That's a reasonable concern. So they put asbestos down. They were very concerned about that. They had a relative who died of asbestosis. So, imagine they felt that way. And they bought a house, an old house that's full of asbestos. And now they find that out. And then they claim verbally, they told you that. They told you that my dad died from that. And I told you I didn't want that. Poor old buyer's agent says, no, you didn't. You didn't say anything to me. You have nothing in writing to document that. So that particular agent wrote down asbestos. When he found out he didn't want to pay for the inspection, he rescinded, or he clarified it with a satisfaction investigation. I didn't put this in this booklet, but if there's anything on this field other than none, you have to also do a RE/MAX connections form, satisfaction of investigation, or have the asbestos inspection in the file. Now, if he'd gotten an inspection, Well, we got the inspection. He told us he was worried about it. There's the inspection. We're done. We don't need the satisfaction of investigation. But if he says, which happened in this case I'm telling you about, well, I don't want to pay for that. Well, the seller's not going to pay for it. We can ask, but the listing agents has already told us, the seller told them they won't, but we can ask. No, don't bother asking. Forget it. Okay, I need you to do a satisfaction of investigation where they say they're satisfied that they've resolved in their mind the issues they raised on the BMI SP in this case. All right. So they are disclosing all material issues. These little clauses are extremely important. This is a get out of jail card when we're sued for issues revolving around they got something they didn't want, or they didn't do an inspection that they should have done, and they claim they had told you about that and you didn't do anything about it. So this is the form they tell you about it on. Okay, real simple, straightforward. If you have any questions with the BMISP, SP stands for specific property, buyer material issues, specific property, give me a call. I'm happy to help you with it. Okay, we've been through the BCA many, many times. I'm going to zoom through it so we get through all the forms, but I'll remind you what's there. This is an excellent form to perhaps initiate a conversation with your principal, whether it be a seller or a buyer, on how buyers agents can be paid, and what the situation with the new real estate environment post NAR settlement, how it works as far as compensation is concerned. So that this advisory, very nicely put together, very friendly language, and you can use it as sort of a outline for discussing buyer agent compensation with either party, because the seller needs to know too how buyer agent compensation works, because as all of you know, many buyers are going to put that in an RPA. I'll show you how in a minute, but they're going to put it in the RPA. They want the seller rather, to pay that compensation that the buyer's obligated to pay to their broker on behalf of the buyer. Pay that to the buyer's agent. All right. So again, paragraph 1 is directed toward the seller, and when the seller lists a property, they agree to pay their broker, and all the language you're very familiar with. Seller may represent both sides, dual agency. Talk a little bit about that. The possibility of the same brokerage company that can represent the buyer and the seller in the transaction definitely exists. And I love this little sentence in there, because avoid saying in dual agency, Mr. Seller, I'm going to represent you, and Libby's going to represent the buyer. Don't use the word represent, because legally, if I'm the listing agent, I'm representing the seller and the buyer. If Libby's the buyer's agent, and Libby, I grabbed you because your name's right there on my screen. If Libby represents the buyer, Libby represents both the buyer and the seller. That's what dual agency is. All of you know that, but sometimes we get a little sloppy. I'm just going to represent you. No, you're not. You represent both sides. There was a major lawsuit over that, and the brokerage and the agent who tried to separate agency between the listing side and the buyer side didn't succeed. So not only is it not the way it works in law, it's not the way it works in case law. Case law reaffirmed that the broker represents both people regardless of the agents. So, so keep that in mind. I'm preaching a little bit, but I just want to be sure. Now, here's the language I teach. You can use your own words, but I like the word to work with. Mr. Seller, this is a dual agency situation, which means our brokerage, and in fact, I represent both the buyer and the seller. But I'm going to just be working with you. I've never met the buyer. See, work with. That's perfectly fine. And Libby, who brought us the offer, wonderful offer, I'm so grateful. It'd be great to work with her. She represents both sides also, because the agency is relative to the brokerage. She works for the same brokerage I do, but she'll be working with the buyer. See, so use that working with, that works. But here we are telling our clients that, because the agency is, specific to the brokerage, the possibility the same brokerage company can represent both the buyer and the seller, even though maybe the same agent isn't working with the both the buyer and the seller. Okay. Broker agreements with buyers. Now it talks about how, what the buyer broker agreements entail and what buyers agree to when they sign a buyer representation agreement with their agent broker. Discusses that. Compensation negotiable, requirement for written agreements. NAR now requires written agreements, or will in a couple of days, right? The 17th, coming up fast, a week, I guess. They will require written agreements when agents work with buyers. The state will require it after January 1. So, and they talk about that a little bit here. So prior to showing a buyer a property or giving a buyer a tour of a property, if the agent is working with the buyer, the agent has to have a representation agreement with that buyer. Now, if the agent who's showing the property works for the seller, then he can show the property, she can show the property as a service to the seller. But as I'm going to go through in detail in a couple of weeks, do not cross that agency line. Don't give advice. Don't give guidance. You can answer questions, but don't suggest things. Okay, but we'll talk about that in another class. All right. So, and then it talks about in January 1, there'll be a law that everybody will have to have a written agreement with their buyer if they're working with their buyer, not just NAR members. Now, the advantages of a written agreement talks about that. They put that in there because, buyers in our current world are not familiar with having to sign agreements with brokers. They haven't done it for 100 years. What are you talking about? I got to have an agreement. I didn't have one the last time I bought a house. My father didn't have one. My grandfather didn't have one. What are you talking about? So that's why that clause is in there. All right. Now, when you're working with a buyer, when a buyer, agrees to pay their broker, there are different ways that the compensation can be paid. So the seller can pay the compensation, and the buyer would negotiate directly with the seller, and that's on the RPA. The buyer's agent can negotiate an agreement directly with the seller. That's in unrepresented sellers. Look at that first time. If the seller is unrepresented, then you can do a single party showing and negotiate directly with the seller. If I have a buyer that I represent buys your house, would you pay compensation to me? That would be credited against the buyer's obligation to pay me. So that's the single party agreement that references. And this is a change to the practice related to the seller's broker's offer of compensation. So they talk about that. They talk about the MLS will no longer have a unilateral offer of compensation. Prohibit sellers, brokers from using the MLS to make offers of compensation, telling you something you now are very painfully aware of. But this is a nice way to kind of guide you to present this information to your clients. Buyer signs it or the seller signs it, and away you go. Okay, the buyer financial and personal information, the BFPI. First thing I want to tell you about this form, technically, this form is not optional. If a buyer signs a buyer representation agreement, the agreement states the buyer will provide this form. And the only thing that the representation agreement says is when the form will be provided. So in paragraph 3G1, I think it's 3G1, but 3G1, the BFPI is talked about on the BRBC, on the buyer representation and broker compensation agreement. Paragraph 3G1 discusses the buyer financing and financial and personal information form, which is the BFPI. So it provides it within 5 days, I think is the boilerplate, or provides it immediately, or vice versa. Now, the reason it's not optional, we're not a police state, you're not a policeman, if the buyer doesn't want to provide it to you and you don't want to, press them for it, there's no law that says you have to do it. This is a service, though, to buyer's agents. Why? Because as I mentioned before, think about this in terms of a buyer buying a house and needing a loan to buy the house. If you were the listing agent, there is no way you would accept an offer from a buyer, take your home off the market, and the buyer hasn't at least talked to a lender and got pre-qualified. Well, what's the guy's credit like? Well, I have no idea. Will he talk to a lender? I don't know. Well, a seller would be nuts. So a seller is going to require at a minimum a pre-qualification. And today, in today's market, I mean, a number of years ago, pre-qualification sort of morphed into pre-approvals. And good listing agents and savvy sellers, of course, will not take their home off the market without some documentation the seller has the financial ability to buy the house. All right. But we're talking about a buyer agent working with a buyer. When you go to work for a buyer, you're taking that time slot off the market. You're no longer available to spend that time with any other buyer. Your time's limited. Your time is valuable. I would argue you'd have to have a head of lettuce. You think I could get that out easier? You'd have to have a head of lettuce to spend time and money. I mean, you're spending some money sometimes driving around, working with a buyer who doesn't have the financial ability to pay you. You should know that up front. Now, if they don't have the financial ability to pay you, doesn't mean you won't attempt to represent them. But now you're going to have to put that in an RPA. See, so this form, don't look at it as just a nice little extra form. Yeah, okay, whatever. Think about it as, I'm not going to go to work for a buyer unless the buyer fills this out. All right, so the buyer identifies themselves, the broker, you identify the buyer, you identify the broker, you identify the representation agreement. The buyer and the broker agree it's beneficial to the buyer identifies in writing the buyer's financial condition. And now here's their financial information and a whole bunch of things to fill out and sort of guide you on, what their ability to pay you. And if they can't pay you, that's okay. We now need to make it an important feature of any offer you write. All right. It's simple, very straightforward. Whoops. So if there's other financial information that's important, 1031 exchange, expected legal settlement. I would find out what kind of lawsuit that was. Yeah, the last realtor we sued, we won. We're waiting for the payment. Ooh, expected inheritance. I'm kind of amazed that's on the form, but okay, because these things take a lot longer than people think. All right. Buyer intends to include a contingency to sell another property, a COP. Good to know that up front. I've had agents represent buyers and not ask them, do you need to sell the house you're in, only to find out they do. That's not very good. You should know. And now you have a form that actually asks that question. There's other information that's really quite helpful. First time buyer, have they had experience before? What kind of time constraints are we working in? So this is a very, very handy form. Information is confidential, just like the BIP, the identification of preferences and priorities. If there's any changes, they will provide you additional forms, and then they sign it, and then you acknowledge a copy of it. All right, notice of broker involved properties, the NBIP, notice of broker involved properties. In order to enforce any continuation period protections, and that is they buy a house after the expiration or cancellation of your buyer representation agreement. They enter into a contract after the expiration. Now, if they're in a contract and the representation agreement expires, you would still be covered. But after the expiration of the buyer representation and broker compensation agreement, they bought a house, you might be covered. And so, as we said before, you'd have to check the box, the appropriate box. I think it's 4C2, if I'm remembering correctly. On the BRBC, there's a box to check and then a blank to fill in number of days. I am suggesting I wouldn't make that more than 90. I don't have an answer yet. I should have one, by Friday. If you can make that continuation period, which is that period you would still get compensated if they bought a house you were involved in. So this form, now a couple of things have to happen in order for you to be compensated. You have to be involved in the property, and you have to have given them this notice or a list of properties you're involved in. So let's take a brief look at it real quick. So here's the notice: identify the buyer and the broker and the representation agreement. Identify the period of time the representation agreement covers, not the continuation period. That's not here. This is the representation period. The continuation period, was the so-called in the past protection period, all right? A compensation agreement, they agree to compensate you if there was broker involvement. If the buyer enters or the buyer enters into a contract to acquire the property, or after the expiration period or any extension, and the broker has provided a written list of those properties. If after cancellation, the buyer enters into a contract to acquire a broker-involved property that you were involved in during your representation period, you would be entitled to compensation if after a cancellation, within 5 days of that cancellation, you provided this form. If the representation agreement expires, you must provide this form before the expiration. If the representation period is canceled, you have the right in the agreement, including the cancellation, to provide this list within 5 days after the effective date of the cancellation. And so then paragraph 4, you'd simply list the property addresses that you are protecting. These are the properties I was involved in, which could be more than the properties you actually physically showed them. Okay. And if not enough room here, you check that box and attach a list. And then the buyer is informed to notify any new broker that they got this list, because if they write an offer on one of these protected properties and one of those addresses up above, the buyer might be obligated to owe both of you, and the new agent may not want to be in that situation. And then the date of the notice, that's very important, because that 5-day window for cancellation or prior to expiration if it's simply expiring. So fill this out, and then the buyer signs it, acknowledging the receipt of it. Okay, hope that helps. Now, the residential purchase agreement, RPA page 2, that is where you can ask the seller to pay the compensation the buyer owes you as a result of your buyer representation agreement. And we've covered this a few times, so I'll zoom through it, but I want to remind you something that is sort of new to a lot of you, and that is separating concession between buyer agent compensation and anything else the concession is being paid for. The concession cannot be earmarked, if you will, for buyer broker payment in any marketing piece, including the MLS. You cannot say the seller will pay a concession 2%, or is willing to consider a concession 2% to pay the buyer's broker. You can't say to pay the buyer's broker. You can say that in the agreement. So don't be confused by that. You can identify the concession for paying the buyer broker separate from any other concession in the RPA. And I'll show you how that works right here. So you see there's seller credit. This would be any credit. And then paragraph 3G3, you check this box, and the seller agrees to pay the buyer compensation on the buyer broker agreement. And you would attach the SPBB, seller payment of buyer broker, to document how much that is. It's not on the RPA. So the seller payment of buyer broker must be attached. That is a separate credit, if you will, from any other credit. If you include the buyer broker credit in 3G1, that will be capped by whatever credits the loan program allows. But the lenders, all the lenders, have agreed that they will not count against allowable credit, in other words, the amount that the seller can contribute to the buyer to affect this purchase. They will not count the seller's payment to the buyer's broker in that calculation. So if they have a loan program that allows 2% credit, and you have a buyer broker agreement of 3%, and you put that in 3G1, the seller could only pay 2% of that 3%. If you put it in 3G3, the seller could pay the entire 3% to you and up to 2% additional for any other credit. You know, you have some repairs, and of course the credits are counted against closing costs officially, but you got a repair request, and gee, let's give me 1% of the purchase price to cover these repairs. We'll make it, you know, pay off, you know, pay closing costs. That will not go over the cap. Hope that's clear to everybody. All right. So let's look at when 3G3 is checked, you must include the SPBB to document the amount, seller payment to buyer broker. So again, you identify the parties, the property, and the agents. And then the seller payment to buyer broker, it's right there. How much are you asking the seller to pay? It can be all of it. It can be a portion of it. You know, seller might agree. The seller has a right to counter. He can counter either the RPA in its entirety on the counter, or he could even list, you know, countering the SPBB. I'll only pay, you know, half, 10,000 of whatever the obligation is. That obligation the buyer has won't go away to the buyer's agent, but the amount the seller pays can be limited, and then the buyer would have to make up the difference. And of course, the maximum payment the seller would be obligated to is the amount the buyer representation agreement states. So if you have a representation agreement, and I talking to somebody just yesterday, and they had a $1 buyer representation agreement. If they don't modify that, they're not going to get $1 more than $1 after August, well, actually August 12th or August 13th, because there'll be no more obligation for the listing agent to pay the buyer's agent through the MLS. So don't, you know, you can go high and then lower it. It's risky to go low and then raise it. That's not recommended. The maximum obligation that the seller can incur is the obligation of the buyer to the buyer's agent as documented in the BRBC. Okay, the buyer represents that he has a compensation agreement with his agent. He will deliver some form of documentation. You do not need to send the entire BRBC. You can send the last page of the BRBC that documents the buyer's obligation. I was told that a broker is requiring listing agents get a copy of a BRBC before they allow buyers agents to bring their buyers to their listings. Don't do that. You do not need the BRBC. You know, that's, you know, if you're not showing the property. And even if you're showing the property, if you're working for the seller, it's your listing, you don't need a BRBC. A buyer's agent who is showing the property, not his own listing, would need a BRBC to show that property. But that's between the buyer's agent and the buyer. It doesn't involve the listing agent. You're not the policeman of this. All right. And then third-party beneficiary, if the seller agrees to pay you and then doesn't pay you, we can go directly to the seller without involving the buyer. That's what this is all about. Makes it a little bit easier for you. And they sign it and you're done. Okay, disclosure and modification. I mentioned this before. The DMBR, the disclosure and modification of a buyer representation agreement. And that basically addresses, you know, by the way, it's intended for use for BRBCs that were revised prior revised 12/22 or earlier. In other words, any version before July 24, 24. That's when the new one was put out. So if you had a buyer broker agreement July 1, this would be the form you would want to modify. And you want to modify it relative to compensation because there will no longer be compensation in the MLS. And the old buyer representation agreement discussed compensation through the MLS. That won't happen anymore. The old the NAR settlement requires a buyer representation agreement, and it has to state a definite compensation amount. Okay, your old buyer representation agreement, there were some that had 0 as compensation. Well, I guess that's an amount, but I don't know. Don't think so. All right, buyer is prohibited from receiving anything above what's in that agreement. So if you had 0 or $1, if you don't modify it, you don't get more. So this is a disclosure to explain that. Once the MLS changes go into effect, they're going to prohibit offers of compensation through the MLS. So you need to modify the representation agreement, the old one. Again, new ones, you sign one up after July 24, you don't use this form if you need to modify it. Modification of buyer's representation, they agree that once the MLS offers compensation are removed, any term allowing the broker to retain the excess compensation, that used to be the boilerplate in the old BRBC, that if you had a 2% and let's say you had $1, let me stay on that track. You had $1, you were still protected in the old form because the old BRBC said anything above that dollar, you get to keep. So if they paid 3%, well, $1, 3% less $1, you get the rest. The default in the old BRBC is the buyer's agent, I'm sorry. The default in the old BRBC said the buyer's agent gets whatever's paid, even in addition to what they agreed to. Yeah. So any buyer representation term that allows the buyer to retain any excess communication from the authority is now unenforceable. And the buyer representation provides some or all of the excess compensation to go to the buyer. The buyer understands there won't be any excess compensation because there won't be any compensation. So that kind of explains that. Hope that's pretty straightforward. Not a lot of you are going to be worried about this because we don't have a lot of old BRBCs. Some of you started using the old form before the new one came out just to get practice, and that was good. I thought that was a good idea. You'll want to be sure to modify it. Either modify it or completely replace it, one or the other. Okay, now to modify the new BRBC, it's pretty straightforward. So the MTBR, modification of term, buyer representation agreement, you identify the broker, identify the principal. You can change the expiration date, because the maximum period of a buyer representation agreement is 3 months. So you can change the expiration agreement. You can extend it, but you can't extend it more than 3 months. So 3 months at a time. And then that's the maximum extension. Okay, and then compensation. Of course, compensation is not fixed by law, but you can change the compensation. I signed a 1% agreement with you, but I'm working pretty hard and I want to bump it up to 2% or 3%. And we'll ask the seller to pay it if you want. But, so you can have that discussion. You can change the compensation amount even on the new form. And then any other terms, just put them in there. And then, people sign it. Don't worry too much about management approval. We're pretty much going to let you do your business your way, as long as you're doing it legally. And we'll find out pretty quickly if you're not. But nobody here, I'm worried about that. Okay, cancellation. The cancellation, a little complicated. I want to kind of go through it very quickly. I don't want to wrap this up. I got one more form, I think, to talk about, and that'll be kind of quick. And then we'll have questions. So the cancellation of a buyer representation agreement, again, you identify the buyer and you identify the broker. Cancellation of buyer representation may be canceled by either the buyer or the broker or both by signing the applicable box below on this form and delivering it to the other party. Now, compensation may still be owed based on other contractual rights. So the buyer is informed. Just because you cancel this doesn't mean you might not still owe me money. Okay, so now here you're identifying who is canceling, the buyer, the broker, or both. And then you look at the effective date of the cancellation. And if the buyer representation agreement is non-exclusive, then the cancellation is effective immediately. Or you want to modify it, you can modify it on this form right here. But boilerplate is it's immediately if it's non-exclusive. If the buyer representation is exclusive, it's effective 30 days after receipt of this notice. And then regardless of the type of representation, the buyer and the broker may agree to mutually cancel this representation immediately or a number of days after the last year. So even though it's an exclusive agreement, if you want to be done with this buyer, you might want 5 days so you can give them that notice of broker involved properties. That's one of the reasons that 5 day right exists, because if we cancel it now, you want some time to do that. So either way, if you don't give yourself time, you still have it because it's a cancellation. Okay, cancellation applies to all properties that may be subject to buyer representation or only one particular property. You can identify a property that the buyer broker agreement will no longer be in effect. Maybe you found out after the fact, oh, another agent showed me that property, and you're willing to back away. That agent's making a claim, or it's indicated, hey, I have a right to commission, my commission, not the commission on the property. Commission is no longer on property, the old MLS way. Commissions are principal to agent, buyer to buyer broker, or seller to seller broker. But you could have a buyer who didn't know he owed a commission to another agent and then told you that in the interest of goodwill. You're saying, okay, let me cancel the agreement relative to that property, and then if it falls out of escrow, you and I are still in business. Okay. All right. Compensation due to the broker, paragraph that covers that. Buyer agrees to pay the broker the compensation specified in either the BRBC or the property PSRA. I forget, that's called the property showing and representation agreement in the event of a cancellation, and you're entitled to that compensation for those properties in which you were involved in. If such a property is acquired during the representation period, you showed them the property, or you gave them a list of properties within 5 days of the cancellation. All right, comma should be in there. I don't know. I'm called cartel. Okay. Or compensation shall be paid as specified in paragraph 3. So you can modify the compensation because they want to be rid of you, you want to be rid of them. And so maybe you'll modify a little bit what the compensation is. It's sort of like canceling a listing. You're entitled, to compensation relative to listing contract, but look, you give me a few dollars, I'll go away. All right. Or I'll let you go, I'll have you go away. All right. So you check that box if paragraph 3 is going to be invoked. All right. So this is paragraph 2E2. Check that, and then paragraph 3 would count. You don't check that, then paragraph 3 is a moot point, doesn't matter. And paragraph 3 is on the second page. So if it's unilateral, either the buyer or the broker cancel. If it's mutual, both cancel. If you've checked that paragraph 2E, whatever I said was, forgot now. But if you check that paragraph, in fact, here it is, paragraph 2E2. Yes, I thought, okay. Then this will apply. Paragraph 3 will apply. So, check A, subsequent acquisition of the property during the representation and extension that there was not acquisition during the representation period. Acquisition of a property that during the representation period or extension, there was broker involvement. A little confusing if you don't, I think a comma should be in there. So, they don't have to acquire the property during the representation period. You have to be involved in it during the representation period. And then if they acquire the property during the continuation period, your contract is no longer actively in effect, but the continuation period is giving you protection. You would still be compensated, and you can modify that in paragraph 3A. Or you can just go away for the expenses you've incurred. You can, I'll pay you X number of dollars, you can go away. Or you can receive a referral fee. I think it's going to be real common. They want to work with another agent. They don't like you. Okay, pay me a referral fee, I'll go away. And likewise, I can tell you this will work in reverse too. We find out a buyer comes to us and says, the other agent's a jerk. He showed me the house. We wrote an offer. It got rejected. I want you to work with me, and I still want that house. You know, in the old days, if we took that on, and we often did after we documented that truly the other agent was a jerk. I'm being kind of blunt here, but this recording hopefully only stays within the company. But if the other agent truly was not working in the seller's interest, or the buyer's interest rather, then the procuring cause complaint, they would have a hard time, the word is perfecting it, sustaining it, they'd have a hard time winning a procuring cause because the buyer wants nothing to do with them. That is not the rules anymore. Procuring cause is not a part of this anymore. If I'm involved in the property and I am a jerk, it doesn't matter. So you may just, we may, I'm talking about in reverse, we may tell the buyer, look, let's pay a referral fee to that first agent because he's entitled to compensation. You want me to represent you, I'm not going to represent you for free, but I'm willing to take from the 3% you're going to pay me, the 2.5% you're going to pay me, 25% of that, and pay a referral fee, make that broker go away, and your life is, simpler. And as I tell agents all the time, it's your choice. You don't have to do it. But I think everybody on this call would gladly pay 25% if somebody from Rhode Island called you and said, I have a buyer wants to buy a house, and they'll work with whoever I tell them to work with. They'll sign a buyer representation agreement with you. Will you pay me a referral fee for that person? That person is my former next door neighbor. We're good buddies. You'd agree to that in a heartbeat. So, anyway, that's one way to cancel an agreement. They would cancel their obligations to the buyer would cancel his obligation to the first agent and work with you because the broker is going to receive a referral fee. Or no compensation or other. All right. Sign that and that. Okay. Now, quickly, this is a simplified buyer representation agreement. And the three factors that the three factors that come into play for this form to be used, and the provisions of this form, just keep this in mind. I'll zoom through it, but this is for no more than 3 properties. That's the maximum number of properties. It can only be non-exclusive, which means you must have broker involvement if they buy one of the 3 properties. And the maximum period of time of this agreement, this property showing and representation agreement, PSRA, cannot exceed 30 days. Now, that can also be extended, but only in 30-day windows. This is a more simplified version of the BRBC. Doesn't have quite as much detail, not as quite as much protections, frankly, for the buyer's agent, but it may be a stepping stone. You got a buyer not ready to sign a buyer representation agreement yet, but would like you to show them this house. If it's not your listing, you can't do it without some kind of a representation agreement. And so, given the fact they say, no, we really don't want to sign a representation agreement, by the way, this is a representation agreement. So I would use dialogue something like, well, would you be open to signing a real simple one? I know if you've looked at the other one, I know it's 5 pages. There's a lot of legalese on it, I'm sure, probably a little bit overwhelming because you've never had to do anything like that before. I have a real simple one. Let's get together, or let me shoot it to you. We talk over the phone. We can do a Zoom call, and I'm happy to show you the property. So this is a way to sort of, open the door with buyers who are not really excited about signing a BRBC. But again, as a buyer's agent who does not have a listing, or have the listing, you have not listed the property that buyer wants to see, you got to have a buyer representation agreement. All right. So identifies, okay, so this is for prospective buyers for up to 3 houses or an open house. See, they want to talk with you at the open house. Yeah, no, I'd like to know more about this house. Can you help me with a little bit? Well, then you can list this property as, as the one property, and it's the open house property. All right. So terms of representation, a little mini grid there. It's real simple, real straightforward. A representation of period can't exceed 30 days. Compensation not fixed by law, amount of compensation, very similar. Payments received by broker from seller. If the broker receives compensation from seller or anybody else, it would be counted against the obligation for the buyer to pay this. So we can ask the seller to pay this on your behalf, and we've already showed you how to do that. And then that would cover the buyer's obligation to you. And then their cancellation rights. And so, when can they cancel? Upon receipt. See, it's non-exclusive, so there's no 30 days. But you could make it like 5 days or something like that if you wanted. We could make it 30, I suppose. All right. Compensation to broker, same sort of boilerplate information. Non-exclusive representation, we've been through that in some detail in the past. It identifies what broker involvement is. It's an excellent definition. It goes a long way to protecting an agent who working with a buyer, and then the buyer goes and has another agent write the offer. And that's what I kind of referenced before. Sometimes they do it with no cause. Agent didn't do anything wrong. Sometimes we get sort of screwed over by that. Sometimes the agent wasn't that sharp of an agent, and the buyer wants to use you because you're much sharper. But this broker involvement has a very broad definition. It does not include sending buyers a list of properties. That is specifically excluded. When you're paid, payments through escrow, accounting for payments. If somebody makes any payments to the broker, it's counted against what the buyer owes you. Detailed there. Cancellation rights. We've been through that already. I think we've done that pretty well. When you cancel, give them a notice of buyer involved properties within 5 days, which would be one of these 3 properties. It wouldn't be more because you don't have a buyer representation agreement to show them more than these 3 properties. Don't use this form and then start showing 4, 5, 6 properties. You're going to have to evolve to a regular BRBC. All right. Dual agency, pretty straightforward. Prospective buyer attending open houses without representation. That's what I referenced before. At the open house, if you're the agent for the seller, and if it's our company listing, you are the agent for the seller, even though you didn't take the listing. So you can walk them through the open house, but you don't represent them. You can't answer any questions other than feature questions. You can't give them advice. You can't give them guidance. But if in talking with you, they kind of like you and they'd like to talk more about this house, don't know if I want to make an offer or not, Walt, but can you talk to me a little bit on it? Love to. Let's have you sign this property showing and representation agreement, this PSRA, and let's list this open house. And now I can be your agent on this house. And then talks about all prospective buyers. Pretty straightforward there. If you've signed another agreement with another broker, you should inform this broker, that they signed another agreement. And that if you sign other forms, you may be obligated to pay other agents. Talked about that. They sign it and they're done. I've been through this before, probably a couple times, very fast. The slides here, the new form, the only difference between what you're going to see on these slides, you have, I think, the new form in your handout. You're going to notice each of these paragraphs are numbered. They weren't numbered when this form was first released. They didn't change anything in this form. So I didn't go through just to add the numbers. And so there's a feature there right there. They intend to view the property. This is an open house signing sheet, if you will. So they want to see the property. You don't represent them. Any communication they give to you is not, is for the benefit of the seller. Any communication you give to them is for the benefit of the seller. Any communication they give to you is not confidential. If they write an offer, at this time, the agent will disclose if the agent's broker represents the seller exclusively, or both the seller and the visitor on the offer. And of course, you'll have to do a BRBC immediately, or a PSRA form we just talked about. And then if they want to be represented, they can do a PRSA. I guess that is one difference. They reference an old form. All right. Now, sign in. Only the main person of each group needs to sign in, and you treat this as a sign-in sheet. So that's pretty much it. I hope I've answered most of your questions about these forms, and if you have any questions, on anything we've covered so far, I'm happy to take a few minutes and answer those questions.
Sissy asks, can we charge a retainer fee? And if so, who would the buyer write the check to?
Cynthia, I should have called you right back. I haven't found out for sure, but the short answer is probably not. There's a law in California, and I know you got that from a guru type who's pretty popular and pretty knowledgeable. I've taught a lot of his material. He's principally a Canadian agent, and he's familiar with U.S. real estate in general. He's not extremely familiar with California because, to get to the point here, California has a law that agents cannot be prepaid. You cannot collect money in advance of performing the service. A retainer fee is money on deposit that we draw from. It is a very complex, the law actually allows for retainer fees to be paid, but it's got to be put in a trust account. And then you have to document each draw from it. It is a bit of a paperwork nightmare. And years ago, when this guy first promoted this idea, it's not the first time I've heard that from this person that you got this idea from. He's a good guy. He means well, but he doesn't understand California law. And California law is pretty detailed about if you do collect money in advance, you can't be paid it until you actually perform the specific service you do. So I wanted to confirm with the heads up at Car Legal. I know almost personally the number 2 guy there, Gov Hutchinson. So I've got to call into Gov. I have a couple questions for him, and this is one of them. Is there anything that's changed? Because I don't think there is. I don't think a retainer fee is going to be possible.
Thank you.
If the MLS printout still shows the CBB of 2.5%, and we're in the negotiation fee, and we're in the negotiation phase, and we do not have a buyer's agreement prior to August 17th, do we need any form to confirm the commission?
Okay, say that again because I think you lost me.
So if the MLS printout still shows the CBB of 2.5%,
yeah,
and they're still in the negotiation phase, they don't have a buyer's agreement, do we need any form to confirm the commission?
Yeah, if you're still in negotiation, if you're not in a contract prior to the 17th, the commission in the MLS, you're not entitled to it at all. That goes away. Now, if you went into contract today, you showed a house that's got a 3% commission, and you showed it, and you don't have anything in the RPA that the seller is paying the buyer at all, and you don't even have a buyer broker agreement, a buyer representation agreement, you're fine, because the contract already stipulates the rules. And the rules are you have earned the commission that was specified in the MLS when the offer was accepted. If your offer is not accepted, possibly, I mean, I want to back this up a bit. It could be possibly, if it's a San Diego MLS, it could be the 12th. If it's a CR MLS, it could be the 13th. It is absolutely certain it's the 17th. If you're not in contract by the 17th, you're in negotiating, doesn't matter. Does not matter. Just like an expiration. Just give you a little tip. Sometimes the tips are worth just as much as the content. An agent, I won't name him, but he did pretty well. He listed a contract. He listed a house subject to the expiration of the listing that hadn't expired yet. And, he made a presentation to him, and he was pretty firm on his commission. And the seller said, oh, I'm going to list with my neighbor. My neighbor's going to cut her commission. Okay, good luck. Call me if you need me. Well, sure enough, they called him 3 months later. My next door neighbor doesn't know anything. So, will you list my property? Our agent was extremely ethical. Yes, but I don't want to list it until your listing expires. So, not going to talk about your listing. I'm only going to talk about what I'll do for you starting on Saturday. It was going to expire Friday night. On Saturday, here's what I'm doing for you. Good luck until then. That agent got an offer. They were negotiating back and forth. They hadn't put it together Saturday. Late in the day Saturday, it looked like they would come together. And I had the pleasant job of telling the seller, you have an obligation to pay us here. You know, that agent doesn't get that commission anymore because their listing expired and they weren't in an offer. You're not protected as a listing agent for your commission on an expiration if you're not already in contract. So maybe I lost you in the weeds there. You're not protected under the new rules, under the old rules rather. They don't grandfather in if you don't are under contract. If you're under contract, the contract specifies how it will work, and that's okay. So get it under contract.
If we have a coming soon listing, but it won't be entered for a few days on the MLS as a coming soon, do you still need the SELM if we register the listing on
Okay, you got a
CRMLS?
couple of problems in that question. A coming soon is not an exclusion. A coming soon it's a status. It's what's the status? Okay, I have a listing. What's the status? It's active. Start showing it. Sometimes we put listings in the MLS as sold. Why? Because it was, it was excluded from the, it was excluded from the MLS. So we're not putting it in the MLS, and then we sold it, and we want that data in the MLS. So it goes in the MLS. I mean, it has to go active, then move to sold right away. It's a status. So coming soon has to be entered within 48 hours of taking the listing. If you're going to keep it out of the list, out of the MLS longer than 48 hours, you must send an SELM in. Now, if that SELM is for 1 week, a week from now, you cannot put it in coming soon because coming soon requires it to go into coming soon as an original input. So you have to make a decision now. Most of the time it's coming soon because you're not quite ready. Well, you got 21 days, then it's going to go active. Well, no, we probably need a month. So can we exclude it for 2 weeks and then put it coming soon? No, can't do it. Does that answer the question? Whoever asked it, I hope it's clear. But you don't have the option to do coming soon later. And coming soon, you don't need an SELM if you're putting it in coming soon immediately because you're not excluding it. It's going in, but the status is don't show it yet. That's basically what it says, right? It's coming soon. Can't look at it today, but you can look at it anytime between now and 3 weeks from now. That's the maximum period of time.
If you and your client agree to a 3% commission on the BRBC, but you decide to ask the seller to pay for 2.5% or another percentage below 3% on the offer you submit, then the seller asks for the page that shows proof of your agreement. Doesn't matter if it's different.
If you're asking the seller pay lower, no. The buyer should be informed. All right, we're only going to ask for 2. You owe me 1. And I would argue you should change that form ultimately because escrow is going to need that BRBC. And they won't pay 2 if they have a BRBC that says 3. I'm not too worried about anybody getting sued because nobody's going to be mad because they paid less. And the buyer can show the seller a BRBC that says 3. In fact, that's kind of a win. Look how wonderful we are, Mr. Seller. Look how nice my buyer is. He doesn't want you to pay everything. He just wants you to help a little bit. You only got to pay 2. He owes me 3. That could be a nice, you put a real nice spin on that.
But what if, Walt,
Yes.
what if you just go with the 2.5 and you don't make your buyer make up that 0.5%?
Yeah, no, exactly. Yeah. And that's what I was saying before me. I skipped over it too quickly. My assumption was if they agreed to 2 or 2.5 and you have a 3, you told the buyer, I'll reduce it to that. I want you to get this house. You owe me 3, but on this house, let's just ask for 2. And I'm okay with that.
Okay.
You want to change it, not so much because the buyer will sue you because you took less money. That ain't going to happen. You want to change it because escrow doesn't want to be sued because they paid you less money. And they are going to require, I'm going to do a talk at the Escrow Association here real soon, next month. And one of the things I'm going to talk to them about are the kinds of things they should be doing. And you know, they are going to be requiring, just like listing contracts, they should be requiring documentation as to why they're charging the seller money. They should not be just taking the buyer's agent's word for it. So sharp escrow companies will want BRBCs. If your BRBC says 3%, the seller's only paying you 2%, that's part of the escrow instructions. The escrow company is going to be worried about that other 1%, because they're supposed to be collecting that from the buyer as part of the buyer's closing costs. And you say, no, 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 I told the buyer to give it up. Good escrow companies will say, well, please document that. Or they're going to do an escrow instruction at the very least.
If you have a listing and a buyer wants to show your listing, must the buyer sign a BRBC?
The buyer wants you to show your listing.
If you have a listing and a
Yeah.
buyer wants you to show your listing, must the
Yeah.
buyer sign a BRBC?
No, they wouldn't have to. Now, sales will kick in here sooner or later. You know, what's your dialogue as far as getting them to sign a BRBC? Because if they want to see the listing, are you just opening the door and letting them see the listing and then next? Well, you can do that. You cannot represent them in any fashion. And I'm going to talk about that in 2 weeks. Representation would include answering their questions other than features. You know, anything that's advice, any guidance, you can't do it. So you're showing the house and they see something, they wonder, well, what does that mean? What's the impact? What do you think? Should I get this pool inspected? You know, what's available to me relative to a septic system? I've never bought a house with a septic system. You can't talk about that. You can tell them I have a septic system because that's a feature. You're answering questions about features for the seller. So, I mean, the shorter answer is, yeah, you can show the house, but you are doing it as a representative of the seller. You are not the representative of the buyer. So don't act like one, you know, answer their questions when they say, you know, when was the roof put on? Well, the seller told me it was put on in 2015. You can say that. That's a factual statement. You know, now they won't ask you how, if that's too old, but if they say, seller told me it was put in 2005. Well, do roofs normally last this long? How much long will this roof last? Buyers ask those kinds of questions. I'm sorry, sir, I'm not your agent. You'll have to seek that advice from somebody you trust or your agent. Now, my sales skills would be kicking in way ahead of time. I'd be suggesting, look, hire me as your agent. You just BRBC here. That's not dialogue, it's an attitude. Okay.
If I have a listing and an agent texts me to see the property, may I tell them that the seller is offering a compensation to them?
Yeah, don't phrase it that way. They're not offering a compensation to them. That you're not, what's happening is the sellers will entertain paying concessions, and the buyer gets to use those concessions for whatever. So in fact, specifically those concessions, I'm going to cover this in 2 weeks in detail, but I want to answer the question because you're out there today. Specifically, the concessions cannot be earmarked. So, no one's recording your conversation. The conversation police aren't going to bust you. I'm not too worried about it, but I want to guide you away from that kind of dialogue, because that dialogue will get you in trouble ultimately because you're thinking wrong. You're thinking, wrong according to the NAR settlement, not wrong, according to life. The NAR settlement says concessions cannot be earmarked to the buyer broker. So if they say, is the agent willing to pay the buyer's agent? Well, is the seller really pay? I would counter slightly with the seller has indicated he'll pay up to 2.5% in buyer concessions, in seller concessions to the buyer. Just keep it, don't link it to representation.
If a buyer goes to multiple open houses in one day, they could potentially be signing a buyer broker agreement for each house, but none would overlap because they'll be specific to that address, correct?
Okay.
Yeah, if they sign a buyer representation agreement, it's only enforceable for involved properties. So if buyer went to house 2, he signed house 1 and house 2, the agent at House 2 can't enforce his agreement against the buyer if the buyer bought House 1 because the broker wasn't involved in that house. So yeah, you're on the right track. That's correct. It must be broker involvement in order for you to be entitled to compensation.
Many agents charge a buyer a TC fee. With the BRBC, is if it's added and the RPA page 2G is checked, essentially a seller would be paying, would be paying this if they agree, unless they counter this on the SPBB1A.
Well,
Is this correct, or can this be countered without using the SPBB?
Let me clean this up a little bit. Stop specifying TC fees as compensation. It's against the law. Remember, I've said this several times. I'm saying this with a smile. The reason I said it several times is I know the practice. I'm trying to wean you off of that. You know, I want to make your life simple, but I also don't want to get you or the brokerage in trouble should there be a problem later. No one's going to be looking for TC fees on listing contracts or buyer agreements. But when they look at a contract and they see that, that's going to be a red flag. And let me tell you how the DRE works. When they find a problem that they weren't looking for in the paperwork, they want to see all kinds of paperwork because they want to know, oh, is this a practice? Is this what the agent does? Is this what the brokerage does? I want to see his last 5 transactions. And this was a complaint that a buyer or a seller had one specific transaction. They go rapid fire to big picture. You know, so it's against the law to specify a TC fee paid to you or the brokerage because all compensation paid to you or the brokerage, you know, actually to the brokerage, of course, is commission. So that's why it says 3% and. So let's say it's $500. Whether it's a seller or a buyer, they're going to pay you 3%. Plus they said, yeah, I'll cover your TC. You make it 3% plus $500. That is going to be compensation. Now on the RPA, you put 3% plus $500 on the SPBB because it has the same thing, a percentage and a dollar amount. If it's a dollar amount, you do the 3% plus 500, add that together in a dollar amount. So get away from trying to figure out how do we deal with the buyer or the seller paying my TC fee. If it's going to you and then you're paying your TC, it's got to be listed as commission. And you know, it's the kind of thing we want to fix over time.
Well, can I just say, no, I understand that. I put TC in quotes because I realize that agents don't write that in contracts, but they do include it as an additional fee. Right. So if a seller is agreeing to pay, say 2.5%, but they don't want to pay that $500 fee, where do we eliminate it? Because on the SPBB, there's not really room to remove it.
Well, you don't remove it on the SPBB. You would remove it from your BRBC. Here's what happened. So you have a 3%.
Well, I'm talking about if I represent a seller and I get an offer from a buyer's agent and the buyer's agent has included it in their BRBC.
Well, when you say included it, I don't know what you mean. Did they include 3% plus my TC?
Well, and you don't say it as a TC fee, but yes, they've also added in a $500.
Right. So it's 3% plus 500.
Exactly.
If your seller says, I ain't paying that 500, you would counter back 3% only.
And you just can do that on a regular counter offer?
Yeah.
Okay, that's all I was asking.
You just take it out. Now the agent, if they did the BRBC correctly, has 3% plus 500. So now the buyer owes the agent $500 because the seller is paying the 3% on behalf of the buyer, but the BRBC still has that 500 on it. And now if the agent wants to take that 500 away, they would do a modification of terms to make it go away. But from the seller's perspective, they just counter how much they're going to pay.
Okay. Okay, that's what I needed to know, where it's countered on a regular standard counter offer. Okay, perfect.
If you modify the BRBC with the DMBR, do you have to modify the expiration date if your original one was for 1 year?
No, no. Agreements, buyer representation agreements that have been entered for longer than 1 year, and they were in place prior to January 1 of 25, they'll still honor. So let's say you have a buyer broker agreement that was 1 year and you signed it in June on the old BRBC, and it's a 1-year form. Well, that's going to still stay in place for 1 year. The law will presumably read that, when an agent enters into a BRBC, it cannot be for longer than 3 months. But you've already entered one in. So they're not to get in the weeds here, but those of you who are civic students and love law, there's a constitutional provision, no ex post facto laws. You can't make something you did legally today illegal tomorrow and then bust you because you did it legally today. So today, legally, you said this is for 1 year. Now today you couldn't do that because the contract didn't allow you to do it. But if you did it in June with an old BRBC and made it for 1 year, or February of this year, it's still good for February of next year because that was in place. The new law says basically no new ones can be more than 3 months.
What
Well-
if oh, go ahead, Libby.
Couldn't we just do one today? Because we still have the old BRBC.
So what would you do?
Couldn't we just do a 1-year one today?
No, because you don't have the old
Changes?
BRBC. You can't use the old BRBC because it's been removed from the library. And you don't want to use it because it has all kinds of compensation. You get to keep the excess. There's all kinds of problems with the old BRBC with the new rules.
Okay,
So if you had an old BRBC, you want to get rid of all those complications, but you don't have to make it 3 months because you were legally allowed to make it 1 year when you took it. You're allowed to do that.
there's gonna be so many addendums, every 3 months.
Well, the transition period is especially complicated because you still got transactions, whether they be a listing or a buyer representation agreement that you entered into prior to this change. And now you've got to sort of deal with the change. And so I think these forms do a pretty good job of doing that. On a case-by-case basis, call me if you're struggling with a new provision in the way we do business, but you have an old provision in your contract. Again, as I said at the beginning, my little announcement, if you have a BRBC or an RLA that you entered into prior to the July 24th, in other words, an old one, you've got to modify that prior to the 12th or 13th because those have provisions in them you can't do. And here's what it means, by the way, just to get in the weeds a little bit. They're unenforceable. You don't change them, and the buyer does not want to do anything on that contract, or the seller doesn't want to do anything on that contract, they get an attorney, you will lose because you have an unenforceable contract. So they've made it, without getting into the weeds, Carr doesn't explain it that much detail, and Walt doesn't either, except in the QA. I'll explain to you. The reason you have to modify them is to make that contract enforceable. No, we're not going to try to do something we can't do. We're going to tell you we don't have to do it anymore. So that's why it's important, the reason it's important to do it is I want your contracts to remain in place. I want your listing to be valid. Now, the seller loves you, no harm, no foul, who worries about it? But what if the seller gets a little irritated with you and wants to defeat your contract? You have a contract that's going well past today, and they're mad at you for some reason. You didn't do anything wrong, and now they're digging around. How can they get out of this? They'll get out of it if you haven't modified it.
What if the buyer puts a fake name on the open house form?
Well, I'm sure you're going to get a few Mickey Mouses and other such names. I mean, I got plenty of them for myself as well. So it's okay. I mean, I wouldn't worry, too bad because you would like to be able to talk with them and you're not going to call them Mickey probably.
With seller
Wow.
permission, can we put seller requests no offers from unrepresented buyers?
Yes, you can do that. I'm going to clarify that for certain, but I have found nothing that prevents that because non-representation is not a protected class.
And this is the final question. Are we required to show our listing to an unrepresented buyer?
Well, be careful there. You're required to perform your fiduciary duty to the seller. And even if the seller, keep in mind, you work at the seller's best interest. I could argue that an unrepresented buyer sees the house and wants to buy it, that it would be in the seller's best interest if I could convince the buyer to get representation, you can buy this house. As opposed to, nope, you don't have representation, you don't even need to come in. See, I would not do that because just because they don't have representation now, when they call you, doesn't mean they wouldn't agree to representation, because that question just before that was fine. Could the seller say, I'm not going to accept any offers from an unrepresented buyer? Yes, that's okay. That's not an agent refusing to show a house. Now, if the seller said to you, don't show it to unrepresented buyers, I would say you have an obligation to explain to the seller what I just said. There are going to be people unrepresented that are going to want to see your house, and I'm okay with that. I don't want to work with them if they buy your house, and you don't want them to buy your house. So we can deal with them getting representation if they want your house. And then I would, I'm bold enough to say this, I would say to the seller, my job will be to convince them to get representation, possibly me. Are you okay with dual agency? Yeah, okay. So be careful about, no, I won't show it to you. That you're going to get, and because the other problem you've got is if that person is in a protected class, there's 22 of them in California. There's nobody on this call that probably isn't in a protected class one way or the other. We all are, maybe. I'm old enough. I'm protected. You can't abuse me. I'm elderly. You can't discriminate against me. We all, one way or the other, might qualify. This unrepresented buyer, if he's in a member of a protected class, they're going to go to that argument and they'll win. Hope that answered the question.
Yeah, that's all the
Right.
questions, Walt.
Any other questions? Great. Well, folks, thanks so much. Again, what I said at the beginning, I really mean it from the bottom of my heart. I love doing these classes for no other reason than I love your commitment to your career. And, there's a difference between people who call me and have listened to some of my webinars. Their questions, they seem to be right on money and good questions. Sometimes I get calls from people that haven't a clue yet, and that concerns me a little bit. So nobody on this call, but if you know anybody, tell them to start listening to these old webinars and start tuning in, because, Mike and I mean, we talk about this frequently, and from the get-go, I will tell you, and I'll say this, I know Mike's on the call, I can see his picture, but you guys got to know this. Mike from the beginning has wanted to be sure we're out ahead of this, get in front of this. And he's made a considerable investment in the resources that he's contributed to me and the staff to do the things that help you get through these changes. We still got a few more things to do, but you're going to do fine. You're going to be fine. The
Thank you, Walt.
wisdom to know the difference.
Thanks, Walt.
All right, take care, folks.
Bye, everybody.
Thank you all.
Bye-bye.
Thank you all.